All right, good afternoon. Today is July 20th, 2020. This is a special meeting of the members of the State Liquor Authority. Present today in person in Albany is Chairman Bradley. By phone, we have Commissioner Ford. Commissioner Ford, can you just acknowledge you're there?
I'm here.
And also Commissioner Fan. Commissioner Fan, can you acknowledge you're there?
Yes, I'm here.
Okay, this meeting is being done remotely, pursuant to the governor's executive order suspending certain provisions of the public office law and the open meetings law. Also in attendance today are in Albany, Deputy Commissioner of Licensing Roberts and Counsel to the Authority Meyerhoff, and myself, Secretary to the Authority Donahue. We have 4 items, 4 requests from Counsel's Office for summary orders of suspension. The first item is item 787I, regarding Queens OP 1274762, AFB Lounge, LLC. With that, I'll turn this over to Counsel's Office.
Okay, Mike Amarato, I believe, is going to present this one to the members. Mike, are you there?
Yes, I'm here. Mm-hmm.
Take it away, Mike.
Okay. Thank you. Good afternoon, members of the board. Office of Counsel submits the subject licensee, AFB Lounge, doing business as Brick Bar Lounge and Kitchen, to the members of the authority consider an emergency order of suspension of their retail on-premise liquor license pursuant to Section 4013 of the State Administrative Procedure Act. Brick Bar was issued a license on June 24, 2014 to operate as a restaurant at 3216 Steinway Street in Astoria, Queens. The principal owner is Zorba, and the bar is located in a mixed-use area. The SLA received information after repeated warnings from law enforcement and 2 prior notice of pleadings served on them in connection with earlier executive order violations. The establishment has been allowing their patrons to purchase alcoholic beverages in violation of multiple guidelines on restrictions promulgated by the SLA in connection with the governor's executive order 202.38 along with 202.43. By allowing their patrons to linger and congregate in a way that recreates the dangerous environment that EO 202.38 seeks to avoid, along with 202.43. This type of violative conduct with crowds congregating in front of the restaurant and bar is becoming very popular around New York City. Law enforcement does attempt to disperse the crowds, but doesn't have the staffing to keep the control of the crowds. EO 202.3 granted restaurants and bars a new privilege to allow them to have their patrons consume outdoor on the sidewalk, consistent with 6 feet apart from each other, not wearing masks if they're standing, and all employees must wear masks, as an avenue to earn additional revenue, but expressly subject to SLA guidelines and restrictions. The SLA then issued clear guidance to ensure that the dangers of on-premise consumption during this contagious pandemic would be avoided with this new privilege. And those restrictions are being violated repeatedly at this location, leading to a similar congregation of patrons. Issues that inside service restriction was designed to avoid. Such violations are dangerous to public health and safety for the same reasons as service inside violations. And despite repeated warning from law enforcement, despite the previous NOP served on the licensee in connection with the earlier violations, the licensee continues to operate in the same manner. The members can have no confidence that this conduct will not continue, and summary suspension is in fact needed. Now, with respect to their prior history and background, the licensee indicated in its method of operation that the premises would operate as a restaurant. And in the past, case number 143170, we received a CNC recently in connection with a June 20th violation of 202.3 and 202.43 and a failure to supervise. Now, in this incident, there was at least 20 patrons lingering and congregating immediately outside licensed premises within 100 feet of the premises. And that CNC is going to the full board on July 29th. Case number 144762, the notice of pleading was mailed out just recently on July 17th. That alleges that on June 14th, the premises was operating over 50% occupancy with patrons consuming alcohol inside the premises. A summons was issued for violating the mayor's executive order in violation of the New York City Administrative Code 3-108. Conduct related to the 202.3 violations and the 202.43 violations. In addition to the prior proceedings, on July 16th at approximately 11:02 p.m., SLA investigator Adrian Beckner made an undisclosed visit to Brick. Service hosts were not wearing masks, neither were the employees, and loud music was being heard from the location. There was a large crowd, 40-plus patrons were gathered in front of the premises. Some were seated at tables being served, and others were on the right and the left of the businesses. And the majority of people were standing and drinking, and only a few people had on their masks. On this particular night, they had barriers set up, so the investigators were able to decipher who was part of the establishment and who was not. And the individuals that were observed, the 40-plus, were inside these barriers that delineated them from the other bars. After their inspection there, the investigators left and they went to another location. And then they returned at approximately 12:14 a.m. And the bar was still open, and that's in violation of the mayor's executive order. At 12:14 a.m., they returned to Brick, undisclosed, and there was a large crowd of patrons. This time, there was more than there was earlier. There was approximately 50-plus people. And these patrons were sitting, and the bystanders were still present and not social distancing. On July 18th, at approximately 8 p.m., we received information, on 7/18 at 11 p.m., the New York City Department of Sheriff's Office was there and issued a cease and desist order. That was through the Department of Transportation. Based upon information and belief, the same type of conduct, the same method of operating was conducted on July 18th as it was on July 17th and July 16th, and on two prior occasions as well. Section 401.3 of SAPA reads in pertinent part. If the agency finds that public health, safety, or welfare imperatively requires an emergency action and incorporates a finding to that effect in its order, summary suspension of an order may be ordered, pending proceedings for revocation or other action. These proceedings shall be promptly instituted and determined. Based on the police records we reviewed and discussion with the investigators and the police office, counsel's office has commenced a revocation proceeding against the subject licensee, and that was provided to members of the authority as Exhibit 1, Notice of Pleading 144130. These licenses can see every day that the way in which they are serving alcohol is leading to the very congregation of drinking patrons that the executive orders were ordered to prevent. They should know not to serve the way from their own observations alone. In addition, the licensee's principal and manager was warned by the police, and they've been cited for prior EO violations on two prior occasions. There can be no doubt that Mr. Iona Zalda knows that he cannot operate this way and not be breaking the law. None of these warnings or appearances of clusters of patrons drinking outside the restaurant have stopped him from serving alcohol in this manner. Visits to this location just last week revealed the licensee has done nothing to change its mode of operation. This premise is being operated in a manner that knowingly and recklessly risks the health, safety, and welfare of everyone involved, their patrons, their employees, the police office will have to respond to the complaints generated by the residents in the area, and the healthcare workers that will have to care for newly infected persons when their symptoms require hospitalization. The executive orders were designed to prevent the spread of a deadly virus.
Mike, I'm going to stop you there. We got it.
Okay.
Let me add two facts that Mike might not be aware of. The first is that I sent earlier today to the members a link to a New York Post story that has video of the scene on Steinway Street in Astoria from July 18th, which is the date that the order that was being discussed was issued. That video, which we're trying to get a non-linked copy of, but we're still working on it, shows literally hundreds of people on Steinway Street, the police having difficulty getting up and down the street, and the mostly younger people in the street being difficult and rowdy. Those were the conditions as we understood them to exist on July 18th. The order that Mr. Amarato mentioned, that issued from the Department of Transportation, it's our understanding from New York City that this is the first such order where a licensee was told by New York City that its privileges in connection with the outdoor dining program plan that New York City sent to the State Liquor Authority for approval, that those privileges were being rescinded. They had a week, I think the order said, we've attached it, and then they can reapply. But of course, at the time that New York City did this, they were unaware that we would be asking the members for a suspension of their license pending the resolution of these charges. So those are two additional items. There's also an additional picture that was added to the record, which we believe depicts the location from above with the crowd outside of it from a neighbor. A neighbor snapped the shot. I believe that's in the July 12th or 13th time frame, so not even the same time period that we have these reports from our own investigators, but a few days earlier. Same scene on Steinway Street with a big crowd in front of Brick.
Okay.
Commissioner Fan, do you have any questions?
Can I just ask Mike again about the dates of the prior violations that were sent out? I think I heard him saying that there was one set of violations that were sent out on June 21, and then the second was sent out on July 17. Is that right? And those were... Sorry.
That's correct, Commissioner Fan. Yes.
And so, so is it safe to say that they got notice of maybe the first set of violations and perhaps not the second, because if we send it out on July 17, they haven't received it yet?
Conceivably so, but again, I'll mention that a conditional no contest offer was proffered to the authority in connection with 143170, so they were keenly aware of the violations, and they were familiar with 202.3 and 202.43.
Okay, got it. So they did respond already, and they submitted a CNC for the set of violations that were sent out on June 21st. Is that right?
That's correct.
Okay, got it. Okay.
Yeah,
that's all.
One thing to add with respect to that, Commissioner Fan, there was a river of people in front of this location. I believe, at least it's counsel's office's position, that at this point in New York State, everybody knows the rules, and there is no excuse that I didn't know that I had been given a violation already, that I believe would stop someone who, well, let me rephrase. I don't think that there would be a defense that anybody who is serving in this fashion, even if never warned or caught before by the State Liquor Authority or given a notice of pleading, that they wouldn't know that serving in this way and creating this crowd would cause an imminent threat to public health, safety, and welfare. Any party, frankly, on Steinway Street that is contributing in any way to the scene that's depicted in those videos has to know that they are contributing to that health risk and should not, in our view, be entrusted with the responsibility of having a liquor license.
I understand. Are there other licensed premises on that same street?
Are there other licensed locations? Yes. Yes.
Sorry, say that.
But the thing that differentiates them from the others is that Bricks is on the side of the street where there aren't too many other places until further down, away from them. Across the street, there are licensed premises directly across the street, based on my understanding, but they don't have any directly next door to them.
Got it. I understand. Okay.
Commissioner Ford, do you have any questions?
It looks like, so there was a visit, on the 16th, 7/16 at 11:02, and a second visit at 12:14. So those are two visits on the same night. Am I reading correctly that they had extended their premises to other adjacent businesses next to them? They had tables out in front of businesses adjacent to them?
That is correct.
Okay. And so they got a letter dated from the Department of Transportation dated July 19th. But it looks as though it says on 7/18 at 11:08 they made another visit. It looks like the tables and chairs had been removed. So it looks like they had removed that before getting a letter. Would that be a correct assumption, statement?
I'm sorry, Commissioner. I didn't hear your complete question. I apologize.
All right. It says, on 7/18, approximately 11:08, and thereafter, I made an undisclosed visit to the assigned locations and observed that the premises had the tables and chairs removed from the front with no patrons in front, and sheriff officers lined up along the front of the neighboring business units where tables and chairs were. But the letter was dated July 19th from Transportation. So in other words, they removed the chairs and tables on their own before the letter came from the Department of Transportation. That's what I mean.
That's not my understanding. My understanding is that the sheriff's department was there and told them that they needed to close up for the night, and then the cease and desist order came the following day.
Got it. Okay.
One other point that Mr. Amarato referenced that on July 16th, when they returned at 12:14 a.m., the crowd had gotten larger. There is a curfew of 11 p.m. for all of New York City under their plan, which they sent to the State Liquor Authority in connection with outdoor service privileges. And although I wasn't part of the decision to go back there, one of the things that our investigators have been doing is to see if that requirement is being complied with. And it wasn't on the night of the 16th as it went into the 17th. It does not surprise me that the New York City Police would be telling people on July 18th to shut down their outdoor service at around 11 p.m., which is apparently what we have evidence of.
Chairman Bradley, any questions?
No.
All right then. Commissioner Fan, your vote?
Yes, as counsel said, outdoor service right now in New York City is certainly a privilege, and this licensee has been repeatedly warned and have been receiving violations and summons from the SLA for things that had already happened in prior months, and so you would think that they know better but to continue to violate the governor's EO and also violate New York City curfew and essentially encouraging a block party to happen right in front of the establishment. And so for creating imminent threat to health, safety, and welfare, to public health, safety, and welfare, I would summarily suspend this license.
Commissioner Ford.
I vote to summarily suspend as well for all the same reasons, expanding their serving area to other businesses that weren't even on their premises. They were the first, as you said, to have their outdoor seating rescinded, if I remember right, if I heard that correctly. So they obviously aren't thinking about. Sorry, is that correct?
That is correct.
They obviously weren't thinking about, playing by the rules that everyone else is supposed to do. So I vote to suspend as well.
Chairman Bradley.
I vote to summarily suspend. This place is a public health menace. The people were everywhere. and they were clearly attached to this restaurant. The owners of this licensee have absolutely no concern for the public health, safety, and welfare of anyone. I mean, the pictures say 1,000 words, so there's no need to even go any further. This place needs to be shut.
All right, the next item is 787J, Saxwood ENT Corp., Suffolk OP 1311104. This is also a request for a summary order of suspension.
Good afternoon again, members of the board. Office of Counsel is going to submit the license Saxwood Enterprises Corp. doing business as secrets to the members of the authority to consider an emergency order of suspension of its retail on-premises liquor license pursuant to 4013 of the State Administrative Procedure Act. Saxwood was issued a license on December 21st, 2018 to operate as a nightclub with adult entertainment. They're located at 3A Saxwood Street, Deer Park, and that's in Suffolk County, New York. The principals of the corporation are William Haverkamp, he's the president, and John T. Gallagher, who is the secretary. The authority received a referral after an inspection was conducted where there was complaints of the licensee violating the executive orders and permitting adult entertainment, which includes pole dancing and lap dancing during the pandemic. Conduct at the licensed premises was a clear violation of the executive order, not only putting the patrons and employees at risk, but forcing police officers and the investigators to close space and proximity to respond to the calls regarding the conduct at the location. Licensee intentionally and recklessly allowed the premise to operate, disregarded the governor's executive orders, and the licensee's actions jeopardized public health and safety by allowing patrons to congregate and serving beverages, allowing them to be consumed inside the licensed premises, and permitting pole dancing and lap dancing. The licensee's conduct by allowing such serious violations to occur suggests he has utter disregard for the law, patrons, law enforcement officers, and the public at large by putting them in imminent and actual danger. The executive order was designed to prevent the spread of a deadly virus, and the licensee cannot be trusted to follow the law, even when human life so obviously depends on adherence to it. Counsel's office refers this licensee for possible emergency suspension action. The licensee indicated in its method of operation that the premise would operate as a nightclub. The licensee's menu filed with the New York State Liquor Authority consists of cheeseburgers, pizza, chicken sandwiches, and chicken tenders. Adverse history is currently case number 140381, pending against this establishment. This case was scheduled to go to a hearing right before the pandemic, and there were 4 charges. Non-bona fide for not having food available for sale, the employment of a felon. Christina Pagian was a felon, and she was charged, and she was found to be in possession of a controlled substance in the first degree and was charged with the intent to sell. Also, charge number 3 is failure to comply with local regs. For security guards, they were employed by secrets and they failed to have a roster, and they did not have general liability insurance or a proprietary license. And the 4th charge was a failure to supervise. The licensee's reckless and callous violations of public health orders issued by the Governor Cuomo in connection with the coronavirus health emergency alone warrants the summary suspension of his license. The owner lied and told Investigator Cervalli when he was there that he didn't have the dancing, stating that they must have done it without his knowledge when he left 20 minutes prior to the entry. However, the owner is on an undercover video buying the undercovers of free round of drinks, bragging about how he was getting away with it. And the licensee was knowingly and intentionally violating the governor's orders and creating a health hazard for these dancers and patients alike, and conceivably spreading the virus with contact with lap dancing and close contact with pole dancing, with girls sharing the same pole. And also at the premises found that night was marijuana cigarettes. concerning this premises with regards to EO violations, on June 30th, 2020, SLA has a report that on that date there was approximately 10 to 15 people at 2305 in the parking lot, which was in violation of 202.43. Next, on July 15th, 2020, at 2250 hours, they conducted an undercover surveillance with video cameras, and the police officer witnessed dancers and patrons without face masks, dancers on poles, and also conducting lap dances as well, thereby violating the minimum distance requirements in violation 202.3. On July 17, 2020, also on July 15, 2020, there was no food available for sale at the premises at that time. Then on July 17, 2020, Suffolk County police officers conducted an undercover surveillance to see if they could get an underage underage agent into the premises. Attempt was denied, and entry was followed by New York State Liquor Authority, Suffolk County Police Department, the Town of Babylon's Fire Marshal, and investigators Chevali observed dances and pole dances and lap dancing as stated earlier. At that point in time, there was 32 persons inside, and that exceeded half of the permissible capacity. And after July 17th is when July 18th that night, investigators Chevali finished conducting his inspection. He found that there was only boxes of pizzas available, and they were unable to produce guest checks to prove that the patrons' food purchases were in connection with the drinks. In fact, one of the police officers was offered a lap dance from one of the dancers, and he reported that people were standing around without masks, drinking, and the dancers and bartenders were up close and very personal, touching patrons, both of which were not wearing masks. Marijuana was also recovered in the dancers' lounge, and it was being smoked inside the premises. A blunt, a bag of marijuana, and 3 partially smoked cigarettes were recovered. Lap dancing records were recovered, showing the cut the club received and the cut that the dancers received. Now, in addition to these charges, we was also brought a charge for focal point for police attention, because there's been a history of crime and serious assaults at the premises, which the authority recently found out about. For example, on June 29th, there was a report of a big fight in the parking lot, and a police officer of Suffolk County PD was on duty, and she responded to the location to an intoxicated patron fighting in the parking lot. During the course of trying to arrest this individual, she was assaulted, and one of the patrons went to grab for the police officer's firearm. She was injured, and she was transported to the hospital. Going back, another example, on January 1st, 2020.
Mike, we don't need to go back that far. We're really focusing on the COVID stuff. So that I think you did a good job with that.
Okay, thank you. So, respectfully, the members can have no confidence that this location will adhere to any legal requirements. There could be no more imminent risk to public health and safety than to allow such obvious and careless lawbreakers to continue to operate while pending charges of process. We respectfully request the members to summarily suspend this license. The public health, welfare, and safety continues to be in jeopardy due to the nature of this particular business and the behavior of the patrons of the licensed premises and the failure of the licensee to take its license privileges seriously. Thank you.
Thanks.
Let me add one thing, that even under Phase 4 of pause in the reopening of licensed premises, the only entertainment permitted in a restaurant licensee is music. Dancing of any kind is not permitted. And if that's your business, to be a strip club, that's probably the one thing you need to know about. Is that legal or not? And this location, when they were caught by our investigators with dancing, the owner tried to explain it away by saying, oh, they must have started dancing right after I left, which is, hard to believe enough on its own. But then he was caught on video surveillance, admitting that he was having a laugh at the people who thought that he was complying and at the governor's executive orders in allowing this conduct and this close proximity of individuals who, if one person who has a lap dance or is on the pole has COVID, everybody else who went there could get it. That was what this licensee thought was appropriate behavior for somebody entrusted with a liquor license. Anyway.
Okay.
Commissioner Fan, any questions?
So just, I appreciate it. Thank you, Mike, by the way. Great presentation. And Gary, so you said in phase 4, the only entertainment that's allowed is music. And so when this establishment in Suffolk County hit phase 4, what they would have been allowed to do is open the bar and serve customers, right? Like they would have been allowed to serve liquor with no dancing, just music.
Correct, as long as the people were seated and socially distanced and wearing masks when they were standing, and the occupancy was less than 50%. Those are the phase 4 restrictions for inside service. There are also Department of Health restrictions for outside service, which I believe they were also violating in their parking lot.
Correct.
And in one of the, is dancing or adult entertainment specifically called out as something that's not allowable in the executive orders? Or it's not that, it's more just like they only mention what is allowed?
I do not believe
it's in our guidance.
I do not believe that an executive order's text says no pole dancing or lap dancing, but our guidance for our licensees on what entertainment is permitted, it limits it to music in certain regards, as do the Department of Health guidelines.
Okay, got it. But then more recently, licensees are told to, in order to serve drinks, they have to also serve food, right? And so, and when did that go into effect?
July
Mike,
16th.
Mike, I'll take this. The most recent executive order that relates to this type of service, which went into effect on Friday, I believe, 17th, concerns circumstances where people are properly seated, but nonetheless just engaged in drinking. Those people must also have ordered food with their drinks.
Okay.
This conduct here is people standing and partying and dancing and touching. The issue of what came into effect on Friday. There may have also been violations there, since there apparently was no food available at all in this location for weeks. They don't serve food at all, which is a violation of our rules even in normal times.
Right.
But and we're charging them for that, and that alone, non-bona fide, has been grounds in the past for this board to simply cancel the license. But the reason we are here now is because they're violating the executive orders that are supposed to prevent the spread of the pandemic, and this place is a problem in that regard.
I understand. Okay. That's all I have. Thank you.
Commissioner Ford, any questions?
Just to be clear, no music in phase 4. You're just talking about New York City, correct?
No, I didn't say no music. I said music was the only entertainment. This place is actually not in New York City. It's in Suffolk County. So they were in phase 4 for the most recent conduct, probably in phase 3 for some of the earlier conduct. But the problem is dancing is not permitted. Lap dancing or other kinds of dancing as entertainment.
Okay. All right, I'm good.
Chairman Bradley, any questions?
Nope, I'm good.
Commissioner Fan, your vote.
Okay. For violating the governor's executive order and, the licensee repeatedly lying about what he has been intending to do with his business, he's created an imminent threat to public health, welfare, and safety, and therefore I vote to summarily suspend his liquor license.
Commissioner Ford.
This place was basically a petri dish for spreading this pandemic. Having adult dancing, as mentioned earlier, with the dances, with the pole, that kind of stuff, violating the rules just with alcohol, so forth and so on. So I vote to summarily suspend as well.
Kevin Brad.
I vote to summarily suspend the there really is no defense to the activities that he had. The language is very clear in our guidance, and not only that, he clearly had knowledge of it based on his own statements to our investigators and felt like he was getting over on somebody, when really all he was doing was putting his employees and his customers at great risk, not to mention their families. So I vote to summarily suspend.
All right, the next item is 787K, Queens OP 1297745, Maspeth Pizza House, Inc.
I believe Stephen Armstrong is going to do this one. Stephen, are you on?
Yes, I am. Good afternoon, Stephen Armstrong on behalf of Counsel's Office in support of the summary suspension of license number 1297745, Maspeth Pizza House Incorporated, located at 5560 60th Street in Queens. Between June 7th and July 19th, this establishment has been found violating the governor's executive orders relating to the COVID-19 pandemic on at least 7 separate occasions. The establishment also has a history of violent incidents, been a drain on NYPD resources for at least the past year. And first, just briefly, for background, the premise is licensed as a restaurant serving liquor, wine, beer, and cider. It was licensed in December of 2016. It's located in predominantly a mixed-use neighborhood. Current method of operation is DJs as well as live and recorded music. They are permitted to have security guards. The current listed principals are Franklin Santana and Louis Selamage. Now, turning to the executive order violations, at least the first we were made aware of, occurred on June 7th, approximately 11 p.m. The NYPD received 2 911 calls stating that there were approximately 100 people inside and outside the premises consuming alcohol and smoking hookah, and that a large fight had broken out in an adjacent parking lot. Upon arriving, police cleared the parking lot to calm the situation. Lieutenant Helmer, who is the Special Operations Lieutenant for the 104 Precinct, spoke directly to Franklin Santana, who, as I said, is one of the licensee principals. Lieutenant Helmer advised him of what he was and was not permitted to do under the executive orders. Because this was their first violation, they simply issued a warning on that date. 3 days later, on June 10th, SLA investigator Charles Travali conducted an undisclosed visit to the premises at approximately 9 p.m. He observed 3 patrons seated inside the premises at the bar drinking what appeared to be alcoholic beverages. 2 days after that, on June 12th, at approximately 11 p.m., investigators Travali and officers from the 104 Precinct again visited the premises. They observed approximately 12 people seated at tables that had been set up outside the location. Many of these individuals were consuming alcoholic beverages. They were also not wearing masks or observing social distancing. There were signs on tables advertising drink prices, and a staff member was observed taking orders. On that date, a summons was issued to an individual who identified herself as a manager. And next, on June 20th, July 3rd, and July 10th, additional follow-up visits were conducted at the premises. Each time the licensee was observed operating in violation of the executive orders. Things like staff and patrons not wearing masks, social distancing not being enforced, patrons being permitted to stand and congregate outside the premises while consuming alcohol. And most recently, just yesterday, July 19th, investigators Travali again observed the licensee violating the executive orders. The premises continued to operate well after midnight. At least 8 patrons were observed standing around tables that had been set up for outside service. These patrons were not wearing masks, not observing social distancing, and were in very close proximity to approximately a dozen patrons who were seated at tables. These first 4 incidents, June 7, June 10, June 12, and June 20, all occurred while New York City was in phase 1 of the reopening plan. And during this period, Governor's Executive Order 202.3 did not permit on-premises consumption of any kind, and only permitted the sale of alcohol for off-premises consumption where it was along with a legitimate takeout or delivery service. And the licensees were plainly not operating a true takeout service on these dates. On June 7 and June 10, patrons were observed inside the premises consuming alcohol. On June 12 and June 20, patrons were permitted to congregate outside the premises near tables that had been set up without SLA approval. The three most recent incidents, July 3rd, July 10th, and July 19th, occurred during Phase 2 of reopening, and Governor's Executive Orders 202.38, 202.43 permit outdoor service on approved spaces subject to limitations put in place by the SLA and Department of Health. The SLA guidance in the relevant part states that food and/or beverages can only be consumed while seated at a table, bar, counter, or similar contrivance. All staff of the licensed business must wear face masks at all times, and all customers must wear face masks at any time they're not seated. Licensee is plainly not enforcing these requirements, and it comes at a time when we're seeing a spike in COVID-19 cases in many cities all over the country. And while New York has succeeded in flattening the curve, the continued success of this requires that people follow rules and guidance. And it's clear from the record that this licensee cannot be trusted to comply with any rules that have been or may in the future be put into place. And that certainly poses a threat to the public health, safety, and welfare. And in addition to their executive order violations, this premises was a problem location long before the pandemic. Since January 1st, 2019, been 131 911 calls for service, including approximately 65 direct patrols. The 104 precinct supports the authority taking the emergency action of suspending the license. In February, we received a letter from Robert Holden, New York City Council member for District 30, asking the authority to take action against this licensee due to the drain on police resources and the constant nuisance it created for the neighborhood. And based on this record, I ask that the members vote to summarily suspend this license. Thank you.
Thank you.
Commissioner Fan, any questions?
Council Armstrong, thank you for your presentation. Can I turn your attention to Exhibit 3? Do you mind just explaining a little bit what those photos represent? Because it's actually a little dark.
Yes, these were photos taken by Investigator Stravali. They're showing, I believe, garbage cans outside that the patrons who were congregating outside were consuming the food and beverages that you see in the garbage cans. See, there's also hookah. The place is not authorized to, or not licensed to have hookah at the premises.
And what is the one with the phone and the, is that just another, that's also showing hookah, the 9th photo?
I see one, it has advertisements for drink prices.
Okay, and then what about the one after that?
I believe that's showing hookah equipment.
Okay. All right, got it. All right, thank you.
Commissioner Ford?
I'm good.
Chairman Bradley?
No questions.
All right then, Commissioner Fan, your vote?
For repeatedly violating the governor's executive order and putting the health of its patrons and staff at risk, I vote summarily this license because of imminent threat to public health, safety, and welfare.
Commissioner Ford?
I vote to summarily suspend for all the same reasons.
Chairman Bradley?
I vote to summarily suspend this licensee has been warned on numerous occasions. He's violated pretty much during every phase of the reopening, and it appears he has no intention of following any of the executive order guidance going forward, and it makes him an imminent risk to the public health.
All right, the next item I have is 787L, Triangle Eatery and Bar, LLC.
I believe Margarita Marcico is going to present this one for Council's office. Margarita, are you on the line?
Yes.
Take it away.
Okay. Good afternoon, Good afternoon, members. I'm making an application on behalf of Council's office requesting that you issue an order of summary suspension as to Triangle Eatery, DBA MIA. I'm sure the members probably remember this premise. They have an extensive adverse history, and I believe they came to the members asking for a second chance because they said that they messed up and they accidentally violated the full board's condition that they actually comply with their stated method of operation and close at 1 or 1:30 in the morning and refrain from using a DJ. They agreed to do this in connection with the prior settlement as a way to try to save their license. In any event, this is probably some of the history, and I'm sure some of the members remember it. I'm sure all of you remember it. We didn't hear very much about MIA during the pandemic. However, in June, we heard from the commanding officer of the 114th Precinct letting us know that there had been a shooting in the vicinity of MIA, and he was concerned. So about a few days later, after initially contacting us, he advised counsel's office that the detectives had been doing their work, that the victim in the shooting had not been all that cooperative. However, the detectives had pieced together what had happened. They obtained videos from neighbors of MIA, and they saw that on June 27th at approximately 1:34 in the morning, the victim of the shooting and the perpetrator actually were walking toward MIA together, and then the tape shuts off. So through this video from the neighbor, they're able to see that they're walking toward MIA. Then through other videos, they're able to see that there's some sort of argument in front of MIA, and there were people standing in front of MIA. And then you see, from the video piece that they described to me, you hear a shot and people are running. The detectives did further work, and they looked in MIA's Instagram, and they were actually able to find a video of the scene that was going on at MIA on June 27th leading up to the shooting. And I think those reports are attached, and the members can review those detective reports. And those reports indicate that on Instagram, they were advertising the fact that they were serving drinks and having a crowd out in front of the premises. After that incident, investigator Stravali went to the premise on June 30th at about 6:40 p.m., and that was a Tuesday, and he observed two males consuming alcohol in front of, and a busboy standing in front of not wearing a mask. After that time, enforcement made a second visit, this time trying to get there after 12 in the morning, and that was when investigator Cesant went to MIA on July 12th, and at 12:15 in the morning, and he observed 20-plus people congregating in front of, not social distancing, and drinking. Those photographs are included. They're a little unclear. I think he took a photograph of the side view mirror, the reflection of the side view mirror of MIA. Maybe he was concerned about blending, but those are the pictures that he submitted. After that, we have an inspection again by Investigator Stravali on July 18th at 7:40 p.m., where he observed 3 males and females standing in front of, not social distancing, not wearing a mask. And then Investigator Stravali also observed that there was a sign where the licensee was advertising ice pops, and there's a picture of the sign where they advertise virgin/alcohol. So they're offering alcohol ice pops in addition to the virgin version of the ice pop, which would tend to indicate that they're not really all that interested in operating as a restaurant, which is what they're licensed to be, and which is what they've repeatedly reaffirmed to the members. That's really what they want to do, and they really want to go back to their roots and be a restaurant. That doesn't seem to coincide with that statement to the members. And so the last visit was by Investigator Beckles on July 19th at 12:20 in the morning. He observed over 20 patrons in front of, and that picture is very clear. That was on a Sunday, and there were tables and chairs out. I did ask the commanding officer if he'd be able to assist us with enforcement, and he, during this time, and he indicated he was so extremely busy with shootings in the housing areas in his precinct, and Steinway Street was keeping him very busy, and that is why you don't see that there's a lot of inspections by the police. They were very concerned about the licensee's lack of compliance generally. I would also note that with regard to the investigation of the shooting, the licensee principal was very uncooperative. He refused to provide any employee names to the detectives who might be potential witnesses. They claimed that their video camera was not working. It was not recording. The owner actually denied to the detective that there were any people congregating in front of or that anybody was drinking, which clearly indicates that the owner understood very well that his license is very in jeopardy at this point, and he knew that it was wrong to allow these people to congregate. The other reason I know that the owner knew it was wrong to allow these people to congregate is because we issued a notice of pleading in connection with Investigator Stravali's first inspection on June 30th, charging them with violations of the governor's orders, and that notice of pleading was mailed on July 6th. So they definitely would have received that notice of pleading before July 18th. But then again, I think their mailbox was getting somewhat cluttered because they'd also just received another notice of pleading, which was mailed on July 7th for yet another violation of the full board's condition that they stick to their method of operation and close when they were supposed to close and not have a DJ. So I just think these people can't be regulated. They just don't seem to care. And I think they're just either waiting for us to summarily suspend them or revoke them at this point. So we're requesting that you suspend them.
Just one thing to add. Thank you, Margarita. The precinct has many complaints about people outside this location, and the key here is the pictures at the end of that stack of pictures, which depict the scene that is, we have no reason to believe, not typical of what it looks like when these neighbors are complaining, congregating, drinking, well after 11 o'clock at night, and a clear violation of the executive order after already receiving notice of pleadings and having other problems in this location that might have caused us to take action had we not been in this shutdown mode due to the COVID pandemic.
Yeah, I mean, they've already paid $60,000 in fines, and they've been suspended for 15 days. So I really think we've tried everything, but and we've given them their chances. And I think they understand what they're supposed to do because they were able to try to convince the members that they really want to do it. So they're knowingly violating all these laws at this point.
Commissioner Fan, any questions?
Hi, Margarita. It's nice to hear your voice.
Thank you.
Wonder if is there any evidence that they were serving food at all, or just the ice pop, probably in violation of pre-mixing rules and everything?
I didn't hear any evidence from any of the investigators that they saw people, eating outside.
Okay.
And the pictures don't seem to indicate that people are eating. They seem to be drinking.
Okay.
Commissioner Ford?
No, I'm good. Thank you.
Chairman Bradley?
No questions.
All right, then, your vote, Commissioner Fan.
For repeatedly violating the governor's executive order and not being cooperative after multiple shootings and other incidents, I vote to summarily suspend this license due to imminent threat to public health, welfare, and safety.
Commissioner Ford?
This establishment was clearly operating in a way that was endangering the public health and safety and welfare, and interested in complying with the governor's executive order, so I vote to summarily suspend.
Chairman Bradley?
I vote to summarily suspend as well. I believe this, the licensee obviously has had multiple chances, but as counsel pointed out, if the violations of, at this point, the violations of the governor's executive orders are what is really affecting or creating the risk of the public health, to the public health, safety, and welfare. I believe this place is in the same general neighborhood as the brick bar that we shut previously today.
No, Chairman. Actually, this is much more residential. There are no bars.
We're talking about it's in Astoria, correct?
It's in Astoria,
Yes,
but
yes.
arguably a different section of Astoria.
But Astoria, as we all know, was rampant with violations. So I think that it's a good sign that we're at least getting two of the serious violators, because both of these bars were clearly violating the governor's executive orders on multiple occasions. So I vote to summarily suspend.
Chairman, I have no other items. You have anything else you want to?
No.
All right then.
Thank you all.
With that, the meeting is adjourned. Thank you.
All right, thank you.